Kupina kuphi emakhaya emadolobheni asekumplasta khona sanimukela ke babukeli. Welcome to yet another installment of Yilungelo Lakho, it's your right. Uhlelo ke lulethela ke indzaba texwayiso nako konke lokuthinta nine njengebathengi. Mina ke bekunene ngisimpiwe ngcongwana. It's still an uphill battle for many cash-strapped sectional title property owners with piling levy fees amongst other financial obligations, but not too many are oblivious to the prospect of losing their properties for outstanding levy fees. Mbukele ke asizingena endzaba yethu namhla kuva ukuthi ke wenta njani ke ukuze ukuthi ungalahlekelwa ke umuntu wakho ngendzaba yema levy fees. Many of us are back from our refreshing holidays, but sadly now we have to confront accumulating arrears, amongst them the levy fees. Kodwa ke yini ke bungoti ke bengakhokhi imali tema levy? Tivashitebene tikhona ke ukuhlanganyela kanye nathi ku Zoom asamukele ke ummeli Levies phinde sibe na advocate Boyce Mkhize lo lucatulula ke tinkinga ke netindzawo ke tema komplazi phecelezi community schemes Ombudsman. Gentlemen, thank you so much for joining us. Welcome to the show.
Thank you very much for having us, Simpiwe. Appreciate it.
Great having you. Now, Ellen, I'm going to start with you. Now, for purposes of, for those of our consumers who are looking to buy property this year, there are certain issues that may not be explained by, by estate agents, such as the levy fees and some of the rates. So what is it that they should know before buying property? I know there's rates, there's levies, and, there's the body corporate fees that may come along. What is it that they should look out for?
Thank you very much. That's an excellent question. The vast majority of property in South Africa is contained in a community scheme. Yes. That means when a buyer is buying property in a community scheme, they have to be acutely aware of what the monthly levy is for the property that they are buying. They've also got to know what the expected utilities are for the property they're buying, as well as any other charges associated with the property. The last thing a buyer in a community scheme wants is a situation where they cannot afford to pay the levy and the ancillary amounts to the community scheme, like the body corporate or the homeowners association. If they do fall into arrears, this can only result in legal action being taken against the buyer, a judgment being obtained against the buyer, and the buyer losing their flat by way of a sale and execution. So all buyers out there, before you buy a flat or a house in a community scheme, please take careful cognizance of the amount of the levies and other charges that you will be expected to pay on a monthly basis. Make sure you can afford them. If not, it can have severe consequences for your financial future.
Now, Ellen, just briefly, is there a difference, though, between municipal rates and levy fees?
Definitely. A buyer has to know that when buying property in a community scheme, they're going to be obligated to pay two separate sets of charges. The first set of charges are payable to the local municipality, commonly known as rates and taxes. Every property in a community scheme on a monthly basis receives a rates and taxes account from the local municipality. That is the first set of charges which a buyer must find out how much they're going to be, the rates and taxes. And the second set of charges that a buyer must ascertain is the levies and ancillary amounts that will be payable to the community scheme. So all buyers out there, before you buy the home of your dreams in a community scheme, make sure you know how much are the rates and taxes, how much are the levies and ancillary amounts. Again, make sure you can afford them. If you don't, it could really affect your financial future.
Now, Advocate Mkhize, let me also bring you in. What is the role then that's played by, the levy fees that consumers need to pay or property owners that they need to pay?
Thank you very much, Simpiwe, and good afternoon to your viewers. The Community Schemes Ombud Service is essentially a watchdog that is been established in terms of an Act of Parliament in 2011 to actually regulate community scheme affairs, if I may put it just in a nutshell. And that includes, amongst others, the issues of governance and ensuring that the rules that are adopted by the schemes are appropriate, they are reasonable, they are not discriminatory in any way. It also includes provisions that have to deal with good corporate governance so that these schemes are managed in a manner that is appropriate and consistent with good principles of practice. And thirdly, it also is there as a watchdog to deal with issues of disputes that arise from time to time between the scheme owners, those that are residents within the schemes, and the body corporates and or homeowners associations, that trustees that govern these schemes, etc. And of course, between the residents themselves. And we do so by determining disputes that get to be serviced with us. Now, the levies are meant to actually, to your question, to manage the affairs of the scheme. And this includes a number of things. The Sectional Titles Management Act, in fact, obligates the schemes, for example, to actually take out insurance on the properties, on each of the properties that are within that particular scheme, to cover it against risk of fire or other potential damages. So that's the one aspect that the levies have to deal with. The second is to deal with the issues of maintenance of common property. So within the schemes, you would find that there are areas which in fact fall in what we can call no man's land. So these are like, for example, the parks or the common roads, etc., and all of those things. All of those are for the account of the scheme, and they get to be financed through the levies that are actually taken from the or drawn from the contribution of the members. So by and large, and of course, there are other administrative and duties that get to be performed. There are security issues, for example. You need to ensure that there's appropriate security in the scheme. The levies basically go towards the payment of those kind of things, perimeter walls, fencing, and a whole host of other admin issues. That's the purpose of the levies.
Ngibani-ke lelo sethela ama-levy nekuthi-ke yini criteria lelo abayisebenzisako kuqhamuka naleli nani or to arrive at that figure nekuthi-ke masipala yena uyangena yini kuloku setha kwala ma-levy?
Masipala ungene kuloku sethwa kwala ma-levy. La ma-levy asethwa abantu laba abangama-members aleso scheme leso. And kufanele babe nomhlangano obizwa ngokuthi AGM noma umhlangano okufanele ubizwe ngayo yonke iminyaka, noma a special general meeting lapho khona abazobhekela khona ukuthi ama-levy lawa angabizwa kanjani nokuthi kufanele abe malini. Ayithathwa le decision abantu kuphela laba singathi ama-trustees. Kufanele le decision ithathwe yibo bonke labo abangamalunga aleso scheme ngoba yibona baba affected ngale mali leyo kufanele bayikhiphe. So they get affected by the levies, and the determination thereof must be transparent, it must be reasonable, and all the parties that are affected thereby must actually participate in that determination. And the levies are therefore set, and they get to be appropriated to each of the members of the scheme.
Okay, thanks for clarifying that, Advocate. Now, Ellen, what is the worst that could possibly happen if levies go into arrears?
The worst that can happen for an owner if levies go into arrears, there can be a number of circumstances which can arise. The first scenario is that the owner gets a judgment granted against them. The judgment reflects on the credit bureaus that operate in the country. And when the owner wants to apply for credit in South Africa, the judgment affects the owner's credit rating, and the owner on certain occasions cannot get the credits that they require, i.e. if they want to purchase a vehicle or another property, the bank or institution may decline the finance because of the judgment against the owner. The second repercussion is that once the owner has a judgment against them, the community scheme is entitled to attach all the movable property of the owner to satisfy the judgments. For example, the vehicle of the owner, all the furniture of the owner. If the owner is in business in their personal name, all the business assets of the owner as well. The third repercussion is that the owner can be called to what's called a Section 65 inquiry, commonly known as debtors court, where the owner is subjected to a financial inquiry examining every detail of the owner's expenses and income, and where the court makes an order that the owner repays the levy arrears in monthly or periodical installments.
Right.
Another consequence is if the owner still cannot pay the arrear amounts, that the community scheme can apply to the court for permission to sell the owner's flat or house via a sheriff's auction, and the owner can actually land up losing the roof over their head. There's one more consequence which we use when we're collecting arrear levies, is we apply to the courts to terminate the electricity and limit the water supply to the owner's flat or house. So an owner in arrears can also land up not having electricity and having a limited amount of water on account of them being in arrears with their levies.
You've raised a very, very pertinent point there, Ellen, with regards to electricity disconnection. After the break, I want us to discuss more as to whether the electricity disconnection is, a legal way to punish a defaulting ratepayer. All this and more coming up in a moment. Please hold your thoughts. Bekune namhla-ke siyaxwayiswa futhi-ke sifundisana kabanti-ke ukuthi singayivikela kanjani ukuze ukuthi-ke singalahlekelwa emakhaya ethu netimpahla tethu ngendaba yokuthi-ke asibhadale ama-rates kanye nema-levies. Today we're joined by Ellen Levies, a property lawyer, and as well as advocate Boys Mkhize. He's a chief ombudsman, chief ombudsman for community schemes. All this and more coming up in a moment. Yilungelo Lakho. Welcome back everybody. Sanamukela futhi babukele ke tincingo tethu sesivuliwe ukuthi nawe ke ungaba ingcenye yalo hlelo ungashayela ke licingo ku 0117146918 noma ke 0117146919 ungasithumela futhi na-email ku consumer@sabc.co.za noma ke usithinze ku Facebook. Namhla ke sikhuluma ke noma siyacwayisana siyafundisana futhi ukuthi ungakuvimbela kanjani kuze ukuthi ke impahla takho noma ke iproperty yakho ungayiluzi noma ke ingadliwa ngendzaba ukuthi akwakhona ukubhadala ama-rates noma ke ema-levy. Namhla ke sinachwephesha ke ma-properties noma ke property lawyer Ellen Levies, siphindze sibe na advocate Boys Mkhize. He's a community schemes ombudsman. Kusixwayisa kabanti nekusiluleka ukuthi ke yini lekumele sikwende kuze ukuthi singalahlekelwa ke impahla tethu. Now advocate, yini ke tikhalo noma ke ma-complaints lehhovisi lakho lelidibene nato ke ngalendzaba le?
Well, there are several complaints and disputes that get lodged with the CISOs, and they range from the very issue that has to do with the levies, where people complain about the issue of the levies and threats onto their properties and the cutting off of services, etc., because they are in arrears. We also deal with complaints that pertain to issues around disputes pertaining to parking, issues of nuisance, noise, the reasonableness of the rules. We just have had to deal with a major matter that has to do with the curtailment of rights that have to do with the short-term lease in the well-acclaimed matter of the blight. And a whole host of other complaints that we deal with. And I think the most important thing really is what we have to make a determination on as the CISOs, amongst other things, is to determine the reasonableness of the rules and the extent to which people have participated in the design and the development of those rules and the acceptance and adoption of those rules. That's part of the determination that we have to look into. And sometimes people tend to neglect basic things, such as I'm going through a difficulty, and then engaging early on with the creditors, which in this case will be the body corporate, and say, look, I'm going through this financial difficulty. This is what my plan is, and this is how I'm going to manage this thing going forward. And it's the best way of actually trying to prevent and preempt the type of actions that sometimes get to be carried out. People don't take any proactive action. They don't respond when legal action is instituted against them, when letters of demand are issued, etc. And before they know it, their house is up for auction, and because it has been attached, etc. So we urge and advise that people must, in fact, take proactive action. They must engage. These rules are rules that are meant to govern the way in which we operate as participants or as residents in those schemes. And it is incumbent upon every person to actually oblige and comply with those rules. And our role as the Ombuds service is to actually make a determination on the reasonableness of those rules. And in terms of the levies being imposed, number one, there is no way we will determine that as unreasonable. It is required for the upkeep of the properties. So that we can never determine as unreasonable. The second issue is that there are legal processes that inadvertently arise where people fail to meet the obligations that they have set for themselves as part of the rules of the body corporate. In terms of those, there is no way that the Ombuds service can then intervene and say, well, you can't proceed with the court action in this particular regard because this particular member is unable to meet their obligations. It is agreed to rules, and therefore they need to be complied with. And we urge members to actually ensure that they comply with those rules, unless, of course, there is an exception where there is an argument about whether those rules were actually, in fact, passed correctly and appropriately, and whether those rules have, in fact, been approved even by the CSOs, because we have to approve the rules, etc. So under those circumstances, we're prepared to look into the issues. Otherwise, we would not be in a position to intervene in areas that pertain to deviations from agreed upon rules, which members are obliged by law to actually abide with.
Yeah, I want to engage you a little bit further on the reasonableness of the rules that I've just mentioned. But for now, let's take our first caller. Sinatsidi ulapha ke Jozi. Sakumole ehleleni sawubona.
Unjani buthi?
Siyaphela unjani mama?
Khona. I've got a question for both advocates, with due respect.
Go for it.
I'm a homeowner of a sectional title property, and my worry is there's been a whole lot of animosity, discrepancies, unaccountability from the trustees or the body corporate in general, including the management agents.
Yes.
I've been taken to court. I've taken the chairman to court. We agreed that he must resign in court, which he agreed to. And I feel like I'm a victim because I'm outspoken. Only because...
Now, Tsida, for purposes of understanding your query, why were you taken to court? What are some of the reasons?
Because I'm asking for documents like bank statements, all the documents that as a homeowner you're supposed to get, you know, as per the CSOs and the constitution of the country. As a homeowner, I'm supposed to be knowing what are the finances for, how much money was used, how much money do we have, the levies and stuff. But you end up being a victim as a homeowner. You end up being taken to court, and there's no maintenance. I'm quite aggrieved. I'm going to be everywhere because, like, my issues are just, you know, have been deviated many times. So now it's trustees with the management cowing towards you as a homeowner and trying to penalize you. So I ended up not paying my levies because I felt like if I cannot get any of the records of all the documents that I'm looking for, so why am I paying? And they've taken me to CSOS, which the case took about 3 years to be finalized. It went for adjudication because I opted for adjudication. And
Tsidi,
I won the case.
you've similarly raised two issues. I mean, my understanding is that you were taken to court because you're not paying
Yes.
levies, but then you're saying that you were taken to court because you kept on demanding some of the documentation that should be due to you.
You end up being victimized because you are looking for relevant information.
Okay.
And you end up being harassed, intimidated by getting all these fake summons. When you go to court, no case has been, I've never actually appeared in court, by
Okay.
the way. I've only appeared in court when I took him for the chairman for intimidation case because he stood up by my gate threatening my life.
Okay.
And the agreement was this man must resign because now the safety of me and my kids is not really yet guaranteed, and he must stay away from all the body corporate matters. And number two, during the adjudication with the CSOS case, I raised an issue that can't CSOS make a plan to come and do an inspection on our behalf so that they are able to see the value of our properties are deteriorating. The minute you start asking for accountability, you are being penalized. There will be burglaries. Our complex is not secured. If you can come here, like you as Ubutsipiwe, you'll see the shock in your
Okay,
face.
Tsidi.
Honestly, yes. There's a whole lot of issues, and I
Okay,
feel like
Tsidi,
I'm a victim
thank you so
here.
much. Yeah, thank you so much. I think we got the gist of your query, and fortunately, we do have a property lawyer, and as well as the community schemes ombudsman. They will both answer your query. Thank you so much for calling us. Tsidi there is from Johannesburg. Please keep those calls coming. You can call us on 011-714-6918 to raise your query. Please don't go away. Welcome back, everybody. Kumbula ke bekunene ukuthi ke nawe ungaba ingcenye lohlelo ongethi ushayele ucingo ku 011-714-6918 noma ke 011-714-6919. You can drop your email, or rather you can email your thoughts to consumer@sabc.co.za. Namhla ke sikhuluma ngeke ungativela kanjani ke kuze ukuthi ke ama properties akho auction noma ke adliwe ngenza bayithi kwabhadali ke timfanelo takhona njengema levies nema taxes nema rates. Namhla ke sine property lawyer Ellen Levy kanye ke ne community schemes ombudsman Advocate Boys Mkiza. But before we get to those two gentlemen, let's take our next caller. Anonymous Ulapa Cape Town. Anonymous, welcome to the show.
Thank you very much.
Please share your thoughts. What's on your mind?
So my question is for Advocate Mkiza, is that with regards to just his comment on adding interest to a special levy on monthly accounts when application was submitted immediately where there was a dispute with regards to a special levy which did not comply with the requirements of the STSMA. There were also no trustees resolutions with regards to raising interest as well as confirmation on the special levy notice which said that it was interest free. So the managing agents and trustees adding interest to an account whilst the matter was in dispute and awaiting in litigation and awaiting an outcome from CSOS. All
right, Anonymous, great chatting to you. Thank you so much for your call. Advocate Mkiza will definitely answer your query. Now, Advocate, we had two callers. Before we went to that ad break, Siberi na Tsidi, the body corporates and the officials there, they've been taking her to court because she's been very vocal in terms of demanding some of the documentation that is due to her with regards to the financial statements and all the other, ensuing cases. And, well, she also said that she decided not to pay her levies as a result of that. Hence, she's been taken to court. And we've also got Anonymous from Cape Town who's querying the issue of, additional levies or special levies that has been added to her account.
Yeah, thank you very much, Cynthia. Just with regards to the first caller, first of all, I mean, the reason why CSOS is in place is to call for accountability.
Yeah.
It is to call for good governance. It is about ensuring that those that are entrusted with the responsibility of managing these schemes do so consistent with the highest principles of ethics and good corporate governance. And this talks to, amongst others, issues of financial prudence. and related considerations. So having said that, the body corporate is the ultimate responsible party in terms of providing the information. Every member of the scheme is a member of the body corporate, and therefore they are entitled to information pertaining to how the scheme is governed, how it is run, how the levies are actually collected and how they are dispersed and how they are managed, a result of which there are also impositions in our practice directives for independent auditors who must actually audit the financial statements of each of these schemes. This is a requirement. So the issues around transparency and accountability is stuff that we stand for. Where the body corporate refuses, fails, neglects to provide the information as required, the members are well within their rights to actually approach the CSOs and declare a dispute in that regard. And our orders have consistently been that where a body corporate is complained against, we will provide that order in order for the members to have access to information that they require. There is also, in addition, in our country, a promotion of access to information, which basically provides for members access to rights in the protection, advancement of their interest or their rights. This is something that body corporates should well be aware of. Sometimes they share this responsibility or defer this responsibility to managing agents. It is still the body corporate's responsibility to actually a board of trustees to actually ensure that they manage those managing agents and they get the information that's required. Now, the protest in terms of which the member decides not to pay the levies is unfortunately not something that is consistent with the legal obligations and provisions. And it's stuff that we would not, in fact, condone in any way, because there is a contractual obligation on each member based on their rules to actually pay the levies. And unfortunately, if a member decides to withhold the levies, they do so at their own risk, and therefore the body corporate may take whatever appropriate action it deems appropriate in that instance. So we would urge against that, rather utilize remedies such as calling for a special general meeting or at the annual general meeting to actually raise those issues and call for accountability and call for the members to actually be exposed to the financials. And if that fails, the members also have got a right to vote out to the trustees that have been elected and to institute or to replace them with a new set of trustees, so that those are the ones that are in fact in line with their corporate governance issues. Okay. We can't unfortunately intervene on the issue of the values of properties. That's a matter that would fall outside of our jurisdiction. It's a matter for the body corporates themselves and the members of the scheme to actually deal with. With regards to the second caller, the issue pertaining to the special levy, the line unfortunately was not too great, but I got to hear that apparently the matter has to do with a special levy being imposed and possibly not complying with the provisions of the Sectional Titles Management Act. Yes, where the determination on the special levies or any other rule or any imposition is made on the participants to the scheme or the members of the body corporate, or inconsistent or without complying with the provisions of the Act and the rules of the scheme, we are bound to actually deem that invalid or to declare that invalid and to then set it aside. But where the members have in fact agreed at the required threshold, consistent with their rules, to the imposition of the special levy for a specific purpose, we cannot intervene in those particular circumstances because it would have been compliant with the set of frameworks that are applicable in that scheme. Okay,
Ellen Levy, I would also like you to weigh in on this, and we've got our next caller, Kaugasi, in Durban, but we'll get to that caller in just a second. But before we get to the caller, Advocate, you mentioned the reasonableness of the rules. I mean, the Ombudsman, the Office of the Ombudsman determines the reasonableness of the rules, and you also mentioned that you do not, determining the value of the property is beyond your jurisdiction. So what's the extent then of the determination of the reasonableness of the rules?
Well, we have to determine that in terms of its impact, the impact of the rules on the members of the scheme.
Okay.
To what extent those rules adversely impact or adversely affect the members of the scheme. Are the rules not just a thumbsuck? Are they not arbitrary? Are they not without any justification or cause? Those are the kind of considerations we would look into. So we would make a determination on a case-by-case basis, based on the particular circumstances, to determine whether the rules are in fact reasonable in that particular locality or particular circumstances. And that's the determination that we make, yes.
All right, thanks for making that point, Advocate. Let's take our next caller. Now, Kawagazi in Durban. Okay, we seem to have lost Kawagazi. We'll try to re-establish connection with the Kawagazi in a moment. But for now, let's take another break. Welcome back everybody. Yilungelo Lakho, it's your right. Namhla ke sikhuluma ke nesiphinde sexwayisane futhi ke silulekane ngekuthi ke ungawuvikela kanjani ukuthi umuntu wakho noma ke likhaya lakho noma ke ma properties akho angadliwa ngendaba yokuthi akukhona ukubhadala ke ema rates nema levies nema arrears nema taxes and all those obligations that you need to fulfill. Namhla ke we've got a property lawyer and as well as the Ombudsman for community schemes. But before we get to that discussion, let's take our next caller. Sina John ulapha ke eDurban. Sakumole John, sawubona.
Yeah, good day. John Hughes here from Durban. Can you hear me?
Yes, I can hear you, John. Please go for it.
Okay. This is all about CSOS, right? All the sectional title schemes, they all pay levy to this organization called CSOS. We had a recent situation where we reported many incidents to CSOS, and they actually did nothing about it. We had proof positive of theft and all kinds of bad caretaker behavior, aggression and everything. And we took the matter to CSOS, and they favored with the body corporate. Even now, this is an existing problem that exists in a place in Margate, right? Am I allowed to mention the name of the place?
No, you may not, but just give us a general overview of the query.
Yeah, the problem here is that the advocate needs to say, what about when CSOS does nothing to help the individual client who's got legitimate complaints, and CSOS just favor the body corporate all the time? It's almost like a cartel, and they never do anything for the citizen that owns the sectional title scheme. And that is the crux of the whole matter. What happens when CSOS does nothing for you? Where's the ombudsman to overlook the super ombudsman?
Okay, John, great chatting to you, and thank you so much for calling. Great question. We've got a property lawyer who will be, dismantling some of those issues that you come across on a daily basis. Now, Ellen, I'm sure you've been listening to the caller. John, is suspecting that there could be a cartel of body corporates because they've always been taking their issues and queries to CSOS, but they always favor the body corporates. And what needs to be done in that particular instance?
Thank you for that question. The CSOS, as the advocate referred to, is a legislative organization headed by 4 provincial ombuds and 1 chief ombud. I would say to the caller that if he has any concerns about the treatment of his case, or if he has any allegations or evidence upon which he bases his call, that he should reach out to one of the provincial ombudsmen or to the chief ombud who we have on air with us this afternoon to voice his concerns and put forth the evidence upon which he bases his concerns.
And earlier on, we also had CD, who's been making a contestation with regards to her, contentions with the body corporates, and she says that she's been taken to court several times because she's been demanding access to documentation with regards to the taxes and the levies and all the financial statements thereof. So the big question is, do property owners have a right to access to such documentation?
That's also a very good question. If an owner lives in a sectional title complex, the law is the Sectional Title Schemes Management Act, and the Act has a set of regulations. In the regulations, specifically the management rules, it's very, very clear that every owner in a sectional title complex is entitled to a whole set of records and documents regarding the complex. Recently, we had the POPI Act, the Protection of Personal Information Act, become effective, and many body corporates, sets of trustees and managing agents believe that because of the POPI Act, that they no longer have to provide owners with these documents. But that is incorrect. The Sectional Title Schemes Management Act makes it clear that the owners have a right to these documents. And the POPI Act says that personal information of owners may be processed, i.e. passed on to the other owners in terms of a legislative provision. So the POPI Act does not stop owners from their entitlement to receive the records of the body corporate. So certainly caller number one is entitled to all the records that Management Rule 27 to the Sectional Title Schemes Management Act and the documents referred to therein. And the POPI Act is not an excuse for the trustees or for the managing agents not to furnish that information.
And caller number one, Ellen, also resorted to not paying her levies as a result of the body corporate's constant and consistent denial of access to such vital documentation. Is that the recourse that property owners should take?
The first advice I would give that caller is please make payment of your monthly levy. Okay. It's very unfortunate, and one could use the word selfish of an owner when you don't pay your monthly levy. What you're then doing is you're calling upon your neighbors to make payments of your share of the expenses, your electricity, your share of the repairs and maintenance to the common property. So the first thing I would do is call upon that owner to meet your moral obligation to make payment of what's owing by you and not to put that burden on your neighbors in the community scheme.
But then are the body corporates entitled to punish the homeowner, other than taking the legal route, punishing them by, for instance, disconnecting electricity? Is that a legal way of punishing a defaulting homeowner?
Community schemes like body corporates are not entitled to limit or terminate electricity. They're not entitled to limit or terminate water, and they're not entitled to limit or terminate access to the complex without a court order. Mm-hmm. If they do so, it's called a spoliation, and the affected party can approach the court to undo the community scheme's unlawful actions. Only with a court order can the community scheme terminate or limit electricity, water, or access.
Okay, Ellen, great chatting to you. Thank you so much. Please stay on the line. We'll take our final break, and we'll be back with more in a moment. Welcome to our final segment. Let's take our last caller. We've got Tsepo from Vicksburg. Tsepo, welcome to the show, and please be brief.
How are you, sir?
I'm very well. How are you? Please shoot straight to the point, sir.
I'm good, thanks very much. There is this issue that I want to find out. Mm-hmm. Body corporates operate through the agent, and they do not have a physical address. Now, if you do have a judgment against a body corporate, how do you go about in as far as issuing out a warrant of execution, because you cannot be attaching the property of the agent.
Okay, Tsepo, great question. Thank you so much for calling. Now, Advocate, ngiyathemba somvile ke Tsepo lapha ukhala ngekuthi i-body corporate operator through estate agent, but then abana address, they've got no abana nzawo lapho ba operator khona. So nangabe kuyenteka ke bafuna ku-attacha, who do they contact? Advocate, are you with us?
Oh, yeah. Thanks. Before I deal with that question, I need to address the insinuations or allegations made by John earlier on.
Yes.
Just quickly, I mean, he raised the question as to what happens when the CSOS does nothing for you, and he makes allegations that there is a cartel of body corporates, a result of which orders are in fact always in favor of the body corporates.
Right.
Nothing could be further from the truth. I want to say categorically that's not correct. We have several thousands of orders that have been made against body corporates. There is no body corporate cartel as far as I'm aware. If there are complaints or concerns about improprieties or irregular conduct of any of our adjudicators or conciliators, my office is available to deal with those. And of course, if a member has an adjudication order that goes against them, they have a recourse in terms of our law to even approach the High Court on the basis of an appeal. So they do have a mechanism to actually even overturn our adjudication order in case the adjudicator did not properly adjudicate the matter. So I just thought I need to lay that to rest.
Okay.
We do our work without fear, favor, or prejudice. We're independent, we're impartial, and we are interested in justice and nothing but justice.
Okay.
The of body corporates that operate through agents. The body corporate, as I indicated earlier on, may subcontract or contract some of its activities or responsibilities to a managing agent, but it is, however, not divested of those responsibilities. And that simply means that it is still equally accountable and responsible for whatever action or inaction on the part of the managing agent. In that instance, a body corporate, in fact, is recognized in the Sectional Titles Management Act as an entity or a legal entity that is capable of being sued or suing, and therefore the service can actually be effected on the premises of the body corporate itself, in the circumstances where the managing agent has in fact taken a hike or something like that.
Let me get that clear, Advocate. I, as a property owner, should I encounter an issue with my body corporate, should I visit the office of CSOs or your office or the Ombudsman or the Community Schemes Ombudsman?
Well, of course, I mean, well, we always encourage members to actually resolve their issues internally first, prior to them escalating them to the CSOs. This is for obvious reason. Two reasons mainly. One, that, you live together in one community. You need to try and create an atmosphere of peaceful resolution and reconciliation of differences and disputes. And to that effect, we then, if the matter gets to be escalated to us, failing resolution at the local level, we start also with a process which is called conciliation, where we try and mediate the dispute between the two parties to try and see if we cannot find an amicable resolution between the parties. It becomes a win-win solution rather than a solution where it is in fact imposed through an adjudication order where conciliation efforts fail.
Okay.
So under those circumstances, we would urge members to in fact resolve their disputes internally, failing which they can refer the matters to us. We've got a website that has got all the details in terms of how to lodge a complaint and what is required, and our website will give those particular details. Thank you so much.
Please share those details. How is your office contactable?
Well, I think the best is to go to our website, which is www.csos.org and .za. That's our website, and our contact details, our emails, etc., and everything will be contained on our website.
Okay, Advocate Mkize, great chatting to you. Thank you so much for joining us this afternoon. And Ellen Levy, as a parting shot, we know that it may be legal to auction off a property as a result of non-payment of municipal rates and levies, but is it a just way of, of getting recourse by the body corporates?
That's an excellent question. A community scheme property, or any property for that matter, in South Africa can only be auctioned off on account of a judgment once a court has taken account of all the relevant circumstances. We all know that Section 26 of the Constitution gives every South African citizen a right to housing. And before any property in South Africa can be auctioned on account of arrear monies or a judgment, a court must take cognizance of all relevant factors. And once all those relevant factors are considered, and once the interests of the owner, who has a right to housing, and the interests of the community scheme, who have an entitlement to receive levies to pay their expenses, are balanced, and once the court makes a decision having considered all factors, only then can a community scheme property be sold via sheriff's auction.
But then, Ellen, is it in the interest of justice that if a property owner is owing rates and levies of, say, for instance, 25,000 Rand, and then his or her property worth 2 million Rand is being auctioned to recover 25,000 Rand?
What we'll do when considering all the factors is definitely weigh that up as one of the contributing items. So often in my practice, where we act for body corporates against owners, we will find a situation where a judge of the High Court or a magistrate of the Magistrates Court will not allow a community scheme property to be auctioned for arrear levies because the amount that is owed is too small.
All right.
So normally the courts will only allow the property to be auctioned if there's a substantial amount owing.
Okay.
Depending upon the value of the property, the amounts of the levies, one's normally looking at between
Ellen,
20
we're out
to
of time,
40,000
unfortunately.
Rand.
Thank you so much for your valuable input and for joining us this afternoon. We do appreciate your time. All right, that was Alan Levy and as well as Advocate Boyce Mkize. And sesifike kanjalo kumaphathelene nehlelo netfu bekunene ngithanda ukubuka kanye tivakashi tide funeka kuba nathi ke kuze kube nyalo ngithanda ukubuka kanye nani ngibabukeli ngithi ke ngithatha isikhathi ukuthi nisibukele namhla from Miss Mphiwe Ngcowane and the rest of the team sesike nisale kahle. Take care and have a great week ahead. Cheers.
Yilungelo